Hello everyone, thank you for joining me for my PIP Monthly February 2019. My name is Javon David and I'm a partner at Secrest Wardle's Troy location. As is the case with every month, I'll go over our case law update for February 2019, and I'll also provide you with some information about a trending topic in PIP litigation. This month we'll be focusing on 3 cases from the Court of Appeals and 1 issue regarding wholesale prices of prescription medication and whether there is sufficient authority to argue to trial court judges that defense counsel is entitled to obtain prescription medication costs or the wholesale price of them in order to defend against a claim. So the case law update for this month begins with W.A. Foote Memorial Hospital versus Michigan Assigned Claims Plan. This is actually a published decision in which the Court of Appeals reaffirms the retroactivity of covenant. In that case of Foote, plaintiff sought the assignment of a claim as a healthcare provider in connection with services it provided to an uninsured person involved in a motor vehicle accident and payment of PIP benefits for those services. Ultimately, in the trial court level, defendants were granted summary disposition on the grounds that, pursuant to the case of Covenant Medical Center versus State Farm, the plaintiff has no direct cause of action against its no-fault insurer. As we all know, in the case of Covenant, the court ruled that the entitlement to seek benefits is a right that belongs to the claimant. Of course, it left open the ability for claimants to assign their rights to these medical providers, which is why we continue to have provider litigation despite covenant. But without that assignment, the provider has no recourse. So on appeal, the plaintiff argued that the decision in Covenant Medical Center, which again establishes that healthcare providers do not have a direct cause of action against no-fault insurers, applies only prospectively, meaning going forward, and not retroactively to apply to cases pending on appeal. This particular case, the Foote Memorial Hospital, was pending on appeal at the time that covenant was decided. However, based upon the analysis of the Michigan Supreme Court in Spectrum Health versus Farm Bureau, a 2012 case, the Michigan Court of Appeals upheld the trial court's decision. The court found that the issues presented on appeal in this case, meaning whether covenant should be applied retroactively, are not factually distinguishable from this particular action. So both cases turn on the fact that a healthcare provider filed a direct action against defendants, which was pending when covenant was decided. Therefore, under the court rules and the rule of stare decisis, which is significantly outlined in the decision of covenant, Spectrum Health, the trial court's dismissal is upheld. So ultimately, this opinion reiterates the retroactivity of the covenant decision, establishing that healthcare providers do not have a direct cause of action against no-fault insurers. Significantly, the decision does not limit its analysis to cases that are newly filed or, after the decision date. Instead, it's retroactive to apply to all cases because the claimant always had the direct cause of action, whereas the provider did not. The next case that came down from the Court of Appeals this month was Malusi versus Farm Bureau versus Citizens. Interestingly, although this was a claim particularly regarding the residency of the plaintiff Malusi, it really resulted in a dispute among the insurance carriers, which were Farm Bureau and Citizens. So just by way of background, the plaintiff, Dane Malusi, was struck by a motor vehicle while riding a bicycle. The primary issue in the underlying case was the residency of plaintiff Dane Malusi at the time of the accident. His parents were insured with Citizens on the date of loss. They provided financial assistance to him, and he stayed in their home. Conversely, plaintiff's driver's license contained his separate apartment address where he occasionally resided with his girlfriend and 2 children. It was well known that plaintiff had a difficult relationship with his girlfriend and would often stay with his parents instead of the apartment. In fact, he spent the week before the accident at his parents' home. He even kept his personal belongings at both addresses. Plaintiff initially sought PIP benefits from Citizens, which were his parents insured, and the claim was ultimately denied because he was not listed on his parents' policy, but he was considered an additional insured within the policy language. After Citizens denied his claim based on the residency dispute, plaintiff sought benefits through the assigned claims plan, and the Farm Bureau was the assigned insurer. When Farm Bureau was brought into the case, they filed a third-party complaint against Citizens and sent a request for admission to Citizens, requesting that Citizens admit that it's highest in priority. For those of you listening that don't do a lot of litigation, a request for admissions is a form of written discovery, and it asks the person you're sending it to admit certain things in a case, and that admission stands for the entirety of the case and serves as their complete admission, and typically will be a bar for them changing what they've said in an admission. So these requests for admissions requested that Citizens admit it was highest in priority. Citizens denied the request. The two companies filed competing motions for summary disposition as to the priority issue, and the trial court ruled in Farm Bureau's favor, citing that there was no question that plaintiff was a resident of his parents' home and no question that plaintiff was insured on the Citizens policy. Following the hearing, the court granted the Farm Bureau's request for attorney fees, as Citizens had quote-unquote no legal basis to deny the claim. On appeal, Citizens argued that the trial court abused its discretion because Farm Bureau's request for admissions dealing with priority was an improper subject under MCR 2.312. The Court of Appeals agreed in a simple and direct analysis. They looked to the court rule cited by Citizens, which is MCR 2.312, and indicated that it cannot be used as an avenue to force an opposing party to admit that the plaintiff's claim has merit. In the context of the lawsuit, Farm Bureau sent the request so that Citizens would admit that their claim had merit. Because the request for admission was improper, Citizens' refusal to make the admission could not form the basis for an award of attorney fees. Therefore, the Court of Appeals reversed the trial court's award of those attorney fees under MCR 2.313. So it's kind of a convoluted issue here, that initially started with a residency fight among disputers, among the insurers. But ultimately, it came down to Citizens did end up being in priority, but that was based on the entirety of the investigation, which meant the depositions, the discovery responses, things along those lines. However, what's key here, and it's important for your own claims and cases in litigation, is if a attorney fee is based on request for admissions only. And clearly the court is saying that that cannot be done here because your request for admission as an initial matter has to be proper. And here, the request for admissions that were sent to Farm Bureau, or were sent to Citizens by Farm Bureau, were improper because they asked Citizens to admit something pertaining to the merits of the claim. So this is something that does come up in a post-dispositive motion issue, but it's just important to be aware that that is something that you can look at if a party opposing you is seeking attorney fees based on request for admissions that you and your counsel prepared together, most likely. Now, our next case for the month is the Sabados versus State Farm case, which reiterated the fact that a statement made in connection with the claim for no-fault PIP benefits is material if it is reasonably relevant to an insurer's investigation of a claim. Now, many of us handling first-party cases are often confronted with the issue of whether or not a material misrepresentation was made, but more importantly, whether or not the representation was material enough to warrant either rescission of a policy or denial of the claim. Oftentimes, you're at the mercy of the judge that's presiding over the matter, and you can present the most brilliant arguments, but the judge may try to find a question of fact to salvage the claim. So we do appreciate when the Court of Appeals looks at these kinds of cases because it provides you with specific case law that you can point to both in litigation when you're filing these motions or working with your counsel to file these motions, or even in the pre-suit stage when you're trying to make a determination as to coverage. You'll have this case law in your back pocket so that you know that, okay, well, the Court of Appeals has looked at this specific issue, so I think we've got a shot. So just some background there, but these cases come down every month or so, and I like to go over them to give you a factual scenario as to how to attack these fraudulent claims. So in this particular case, the plaintiff was involved in an accident while driving her son's car. At the time of the accident, plaintiff was a named insured under defendant's no-fault policy. She alleged she was injured in the accident and made a claim for PIP benefits. In support of her claim, she presented that she could not drive and had not driven since the accident because of her injuries. Plaintiff has also claimed driving as one of the replacement services to which she was entitled. During plaintiff's deposition, she was confronted with the possibility that there was video evidence of plaintiff driving to her own deposition. When faced with this suggestion, she conceded that she could drive. So, based on the plaintiff's deposition testimony, defendant moved for summary disposition. Defendant's motion argued plaintiff made misrepresentations about her injuries and that consequently her claim was barred under her policy's fraud exclusion provision. The trial court agreed, and then the plaintiff appealed. The Michigan Court of Appeals explained that to void a policy because the insured willfully misrepresented a material fact, the insurer must show that the misrepresentation was material, number 2, that it was false, number 3, that the insured knew it was false at the time it was made, or that it was made recklessly without any knowledge of its truth. Or 4th, that the insured made the material misrepresentation with the intention that the insurer would act upon it. Further, a statement is material if it is reasonably relevant to the insurer's investigation of a claim. In this particular case, the plaintiff did misrepresent that she was unable to drive as a result of the accident. This was considered a material misrepresentation because it was evidence of the severity of her injuries, which was reasonably relevant to defendant's investigation of the claim. The misrepresentation was also material because plaintiffs claimed driving as one of the replacement services to which she was entitled. Obviously, plaintiff knew her statement was false because she drove to her deposition before she gave testimony that she could not drive. There was no dispute that plaintiff intended to defraud defendant into relying on these material misrepresentations so that defendant would pay her replacement services claim that she ultimately clearly did not require. So the Court of Appeals affirmed the trial court's decision dismissing her case. And the ultimate rule that comes from this is that a statement made in connection with the claim for no-fault benefits is material if it is reasonably relevant to the insurer's investigation of the claim. And you always want to, work with your counselor, or make the argument at facilitation or whenever you're available to, that these misrepresentations were made for the sole purpose of having the carrier pay for her claim. And that, goes certainly to the willfulness and the motive of providing that type of misrepresentation. So this particular case is a good example of how to use facts regarding fraud in support of a dismissal of a lawsuit or in your assessment of whether or not to pay on a claim pre-suit or to, take the risk and issue a denial and have it go into litigation based on the misrepresentations that you're receiving. Those are all of our cases for the month. And now we've got the trending topic in PIP litigation, which is something that has always, been a topic of interest, is whether or not we are entitled to more information from providers regarding certain services and goods that they provide. Specifically, we often see in the no-fault arena that charges are seemingly excessive, that MRI fees are very high, prescription costs are very high, and that they're often very different from what's charged to Medicaid, Medicare, or a health insurance carrier. So fortunately, over the years, there has been case law that helps us in investigating the costs of these goods and services. And we've done that in different ways with MRIs. But now we continue to do that with medical devices or with prescription copays, especially now that we're seeing that a lot more pharmacies are popping up and charging very high numbers for pretty routine kind of care and kind of services. So how do we get the information from these providers regarding what they actually pay, meaning the wholesale cost for the goods that they are ultimately charging carriers for. And one avenue to do that is using the Bronson versus auto owners case that came down in 2012. And just by way of background, Bronson is a case that held that a carrier is entitled to review the wholesale invoices of medical equipment, which is delineated in billing to an insurer. The Bronson court dealt with the narrow issue of whether or not defendants were entitled to information pertaining to the cost of surgical implant products to plaintiff in the case when defendants were determining whether the charges billed were reasonable. The Bronson court relied on the AOPP decision, which I can provide a citation there, but it's AOPP versus Auto Club 257 Mich. App 365 2003. And they ultimately say that while that case law supports an insurer's practice of determining the reasonableness of a provider's charges for surgical implant products by comparing those charges to the amount charged for those products by other similar providers, AOPP does not suggest that that is the only permissible approach under the No Fault Act. Instead, that case specifically declined to delineate permissible factors that allow carriers to investigate the reasonableness of costs for goods and services provided to no-fault claimants. The Bronson case specifically states that the provider has a burden of proving by a preponderance of the evidence the reasonableness of its charges. Parties are free to introduce evidence to the fact finder, meaning the jury, regarding the reasonableness of their charges. And the plaintiff can argue that its charges are in line with those of other similar providers for, in this particular case, the surgical implants that were at issue. Defendants, per the court, can respond by asserting that a plaintiff's markup over the average wholesale cost of the products clearly renders the charge as excessive. But ultimately, and the court reiterates this over and over again in the opinion, it's the plaintiff's burden to prove that the charges are reasonable. It's not the defendant's burden to prove that the charges are unreasonable. Nevertheless, the court ultimately found that determining the wholesale price for the surgical implants did go to the issue of whether or not a charge was reasonable for the surgical implants. And in doing so, it allowed the parties to engage in discovery in which the defendant could have obtained that information to help them adjust the claim and determine whether or not the charges were reasonable. So Bronson was a case in 2012. We've utilized this to obtain other wholesale costs for different goods and different medical devices that are being charged at sometimes 100 times the actual wholesale cost, or 100 times more than what you can even order it for, like a back brace or something, or a heating pad on Amazon.com, or just going and picking it up from your local drugstore. So sometimes you can do your own research and even have effective arguments at case evaluation or so, or even in dealing with negotiations with these providers, that if you went and bought, for example, a back brace or things like that, then you could have gotten it for a tenth of the price. Another issue that comes up is whether or not you can get these wholesale price for prescriptions from these pharmacies that are charging, again, sometimes 100 times the cost for prescription medication that are often over the counter or something that they could have gotten for a significant reduction from Meyer or any major prescription company. So largely the fight between the provider and the production of information regarding the wholesale cost is going to happen in litigation. But as claim representatives listening to this podcast, it's important to understand the argument so that you can work with your defense counsel in pursuing this information. If you feel as though a pharmacy or some other medical device company is charging an excessive rate, have your counsel file a motion to try to get what it actually costs them to purchase those kinds of items. And you can do that using the Bronson case law, because Bronson doesn't necessarily limit the discovery of wholesale prices to surgical implants. Yes, that was a key issue in the case, but a surgical implant is a good. A prescription is a good. And a back brace or heating pad is a good. So I've made the arguments to judges on numerous occasions that these two things are similar and that because Bronson allows for the discovery of wholesale prices for surgical implants, then in turn, the discovery of prescription copay or prescription pricing or medical brace pricing is also something that I'm allowed to have access to so that my carrier can properly adjust the claim and determine what charges are reasonable. So the bottom line is that you can utilize Bronson to obtain this kind of information. Typically, the result is going to depend on the judge. Judges, I feel, have been receptive to this argument over the years since Bronson came out, and they will allow you to obtain that discoverable information regarding prescriptions or any other kind of medical device. Sometimes they won't, but it's just something that is certainly worth pursuing, or at least trying to get, in order to help you with your understanding as to what these things actually cost. So with prescriptions in particular, it can get a little tricky, and your counsel will have to know how to read the documents that are produced. Sometimes the court will order that the wholesale prices be produced on a particular prescription or medical device, and then you'll just get a hodgepodge of documents that seem to not really mean anything. But you want to make sure that what it was produced was actually what the court ordered and what you asked for. And you can retain bill review experts to go through them and make sure that you got the documents that you needed, and then they'll do an analysis for you based on the documents and tell you what the markup was. And I think oftentimes it helps to have that expert look at it because they'll be testifying on your behalf at trial. So you and your counsel are doing the legwork to get all of these documents, send them to your expert, and have them comment on the kind of markup that was done in this case and how those charges are unreasonable based on what the wholesale cost was. So that is seemingly the hot topic in PIP litigation. I think we're seeing a lot more providers popping up that are providing goods rather than these services, and they're charging 100 times or so more than your usual like CVS or Meyer Pharmacy or things like that. So if you have any questions, feel free to contact me. My name is Javon David. I welcome your questions or your comments, or if you have any topics that you think are trending topic in PIP litigation that you would like discussed at some point, we are taking suggestions. Thank you for listening, and I look forward to you tuning in next month.